Hello viewers, welcome to Ekam Academy. As part of the concept of the day series, today we'll be discussing about center-state relations. As some of you have asked me in the comment section, today we are going to discuss about the center-state relations, especially in legislative as well as administrative field. So financial aspects I'll cover in another video because the length of the video will extend to half an hour. So that is the reason today we'll be discussing two major aspects of center-state relations. First, let us understand. Before that, we have an important announcement from Ekam Academy. For those who are preparing for UPSC Group 2 mains, there is important announcement. We are going to start a test series from now November 11th, and this particular test series include 18 sectional tests with 3 grand tests along with detailed explanation copy as well. So this will be available in Telugu as well as English medium. At the same time, this particular test series also includes last 6 months AP related current affairs as well. So entire package is available only at the cost of 999 rupees. So without any late, you can enroll in this particular course by contacting us on this number. Right. So first, today we are discussing about the center-state relations, as I told you. And first we need to understand, as India is a federal state, right? Not completely federal, but we are mostly federal. So in that aspect, we need to understand there is a clear division of power between center and states by the constitution itself, which is the main source of Indian law, right? So first we need to understand in what aspects do we have this center-state relations. So to ensure that smooth coordination between center and states, so constitution has divided the powers between center and states into legislative, administrative as well as financial divisions. Okay, so financial. So these are the three main aspects. In judiciary, there is no division of power because we are having integrated judiciary instead of independent judiciary, right? So along with independent judiciary, we also have same chain of network or judicial network which is enforcing both central law as well as state law. That means, for example, Supreme Court can also look into state related issues. At the same time, State High Court can also intervene and it can also check whether any law passed by Union Parliament is in violation of fundamental rights or against the constitutional values. So that is what the meaning of integrated chain of judiciary. So we don't have any judicial division of power, right? So then with respect to legislative powers, what is the main thing we need to remember? This is mentioned in from Article 245 to Article 255, especially in the Part 11 of Indian Constitution. So Part 11 of Indian Constitution from 245 to 255 deal with the legislative powers of the center as well as state. So first, what is the territorial extent? That means any law passed by Parliament will apply to which particular region. That is the first thing you need to understand. So Parliament law passed will be applied in the whole of India, or it can be applied only to a part of India. Not only this, it will also have extraterritorial jurisdiction. So what is the meaning of extraterritorial jurisdiction? That means any law passed by Indian Parliament does not only apply to those who are living within Indian territory, but to those who are also living outside India or abroad also. For them also this will apply. So that means citizens or properties held by Indians outside India also will be under the ambit of Parliament law. That is what the extraterritorial jurisdiction of Parliament. So then what is the aspect of state legislature? The law passed by state legislature can be applied to the whole state or part of any state. So that is what the territorial extent we need to understand. Then there is also distribution of legislative powers by the constitution in between the union and the states in the form of 3 lists. So we know there is a union list, there is a state list, and there is also a concurrent list, right? So we know this, and we have borrowed this 3 list system from Government of India Act 1935, right? So union list means only the things which are mentioned in the union list can be enacted by Parliament. So Parliament only can make laws with respect to these things. Then what are the state list? State list aspects means those which are mentioned in the state list can be enacted by state legislature most of the times, but in some situations, which are those I'll explain in the next slide. So those situations, under some exceptional situations, Parliament is also empowered to make laws on the matters of state list. Then what about the concurrent list? Concurrent itself means both union as well as state. That means here Parliament and here it is a state legislature. Both of them can make laws in the matters of concurrent list. So then what is the question? First question of the day means you need to answer in the comment section how many subjects are mentioned in the union list as of now, state list and concurrent list. Please put your answer in the comment section. And then we also need to remember here there is 42nd amendment in the year 1976 which has taken 4 subjects from the state list and it has placed in the concurrent list. And what are those 4 subjects also? Try to put your answer in the comment section. So 2 questions asked so far. Then what is Article 248? So we have seen all the subjects mostly will be either in the union list, state list or concurrent list. But some remaining aspects which are not covered in either of the lists will be considered as residuary list, and this power is vested with the centre. That means Parliament is having this power to enact laws on any matters of the residuary list. So what is the residuary list example? Disaster management. If you have remembered, disaster management in all this aspect is not covered in either of the 3 lists. It is part of residuary aspects, and that is why Disaster Management Act of 2005 was enacted by Parliament of India, right? So these are the things which you need to remember. Then, so I just told you when we have discussed about the state list that in terms of some exceptional situations, not only the state legislature but Parliament also can make laws with respect to state list. So what are those? Means 5 exceptional situations. So what are those? First one, Article 249. So here, in case of Rajya Sabha being the house of the states, if it feels that in the national interest it is very much important to bring any law in the state list, then it can initiate that particular process by passing a bill in the Rajya Sabha with 2/3 of majority. That is what you have to keep in mind with respect to Article 249. That means the initiation should come from Rajya Sabha. In the national interest, if it fails, it can make a law in the state list. Then Article 250. Article 250 says, in case if there is a national emergency, at that point of time, centre can make laws with respect to state list issues also. That is what 250. Then what is Article 252? 252 says, when 2 or more states request Parliament that we want a law of any particular issue by you, that means with Parliament regard, then that particular law can be passed by Parliament, and we have to keep in mind this law will only apply to this particular states. So that means if any law also or any state wants this particular law, they have to again join this particular act by passing this particular bill in their state assembly. Then what is Article 253? 253 says to meet or to comply with any international agreement, Parliament can make a law in whole of India or part of India to ensure that India is complying with any international agreement. So that is what international ratification, that is what we call Article 253. Then what is Article 356? As you know, it is very famous. In case of President rule or state emergency, then also Parliament is empowered to make laws with respect to state list subjects. So these are the exceptional 5 situations where the centre is becoming powerful to make laws on the state list issues. Then, so how the centre is controlling the state legislature or state legislative aspects. That means we have to keep in mind here an important article which was so much controversial in the recent times, and it was also in news because Article 200 talks about the power of governor to reserve any bill passed by state legislature for the presidential consent. So you have seen Tamil Nadu case, in the previous instances Telangana case also. So many times governors, after passing the bill by the state legislature, when it is coming for their consent, they are reserving the bills for the presidential assent, and there is no time limit also stipulated in this regard. That is why it is causing inordinate delay to these bills which are already passed by state legislature. And Supreme Court said you cannot sit on the bills, you need to approve or you need to disapprove it as soon as possible. So that is what you have to understand in Article 200. Then with respect to executive powers or administrative powers, so here we have seen so far is the legislative power. Now under same part, that is part 11 of Indian Constitution, from Article 256 to Article 263, we have a list of administrative powers delegated between the centre and states by the Constitution of India. Now let us understand what is the executive power. So in which aspects union government can have the executive power means those aspects on which union can pass laws. That means Parliament in which aspects it can make law. In those aspects union government have the power to execute those laws passed by Indian Parliament. Same is the case with the state government also. State government can have the executive power with respect to the matters passed in the state list issues. Then what is Article 256? Any issue. So that means, for example, if a state has to take any executive decision, it has to comply with the laws already passed by Indian Parliament. That is what stipulated under Article 246. And what is Article 257 saying? Whatever the state is having the executive power, that can be controlled by the centre in some situations by issuing certain directions. That is what under Article 257. Then during emergencies also, centre becomes all powerful and states become less powerful, you can say. So what is the nature of relation during the national emergency and state emergency means, in the times of national emergency, center becomes all powerful and it can issue some directions in the executive domain that states have to do this and all. In that way, the states can be asked by the center to make some directions in the executive domain. That is what the nature of relations at the time of national emergency. Then in the terms of president rule, so president rule itself is saying that presidents become all powerful. So president means he is the executive head. So executive is controlling. Who is the president? He is the central executive head. So he is trying to control the state executive, or he can also issue some directions for effective implementation during the constitutional failure. That is what in the case of president's rule. Then State Public Service Commission. So what is the main issue here? State Public Service Commission is a constitutional body, but still, although appointment is being done by the governor, but still members of the State Public Service Commission can be removed only by the President of India. That means here center is also trying to control some executive aspect of the state. Right? So removal of the SPSC members by the president itself is the executive control of the center. Then All India services. So we know Indian Administrative Service, Indian Police Service, as well as Indian Forest Service, or All India services, and these people are recruited by the center, but then generally posted in the states, or they will have to work in the state cadres. But if you see, the training and everything is taken care by the center, but the pay and everything has to be borne by the states. That means, again, in this aspect also, that means who are actually running the state governments behind the scenes. So those persons are actually recruited by the center. In that way, center is also trying to control the executive aspects of the state. Then next, other provisions which are maintaining the administrative relations between center and states, or Article 355. According to Article 355, it is the duty of the center to protect the state against any external intervention or aggression. That means, so it has to protect the state against any external aggression. That is what we have to keep in under Article 355. Then the office of governor, or the process of appointment of governor itself is also the dispute, because the office of governor was borrowed from Government of India Act 1935, but still, if you have seen, the concept of appointment of governor by the center is taken from Canadian Constitution, right? So that means governor is the executive head of the state, but still he was being appointed by the center, and he is also functioning the constitutional role of like the head of the constitution in the state. At the same time, he is also maintaining the role as the center's agent in the state. So in that way, he is maintaining the dual role. So that is also how the administrative relations are shared between the center and states. Then appointment of State Election Commissioner. Just now, as we have seen, in the case of State Public Service Commission, same is the case here also. State Election Commissioner, although he was appointed by the governor, he will be removed only by the President of India to ensure his independence and security of tenure. So these are certain aspects in which center is having some administrative relations with the states. So rest of the financial powers I will try to cover in the coming videos. Please do watch those. Then prelims question yesterday's question, you can see, consider the following statements regarding the office of governor. So he or he holds office during pleasure of president. Yes. So who are all holding the office of pleasure during the president's tenure? That means it is Attorney General or Advocate General, Governor, as well as Prime Minister and Council of Ministers during the President's pleasure. And here it is the Chief Minister and the Council of Ministers during the Governor's pleasure. Then Constitution mandates a governor for each state, with no two states having the same person as the governor. So it is not mandated actually. So Constitution has said there should be one governor. There has to be one governor. It's not mandated, and no person there is no restriction that one person cannot be governor for, or one person cannot be governor for two or more states. So this is not correct. So then Constitution does not provide any qualification for appointment of governor. No, it has provided some qualifications like citizen of India, 35 years of age. Only those are the two qualifications provided by the Constitution of India. So the answer here lies one only, right? Then today's practice question. Which of the following subjects were transferred from the state list to concurrent list under 42nd Amendment 1976? Among these, which you feel is the correct, try to put your answer in the comment section. Then Today we have discussed about the center-state relations, especially legislative and administrative relations. So we'll cover financial relations in another video. Please do watch. If you like the videos of concept series, please let me know any further topics if you want from my side. I'll try definitely do those topics which are asked by many of the students. Thank you for watching. All the very best.